It's been 24 hours since the NFL has appealed the decision of Judge Sue Robinson in the Deshaun Watson suspension case. It looks now as if the NFL has the upper hand. And now the biggest question is, what can the NFL Players Association along with Deshaun Watson do to counter this move? I'll dissect this thing and break it down to the molecules and give you fact over fiction and facts over emotions. And we'll do that coming up next on the Barbershop. Okay, so we're back at it again. I want to thank everybody for subscribing to the channel. If you like my content, you can definitely subscribe to the channel, the Barbershop. Hit that notification bell, hit that like button so this gets shown to a lot of people. I spend a lot of time formulating these ideas. I spend a lot of time talking about this stuff, going over documents, figuring out who has the upper hand in this situation, either in the NFL or the NFL Players Association. Just to put a disclaimer out here, I'm not a lawyer. I have no legal background. I'm a college graduate. I graduated in marketing communications. Obviously, I'm a sports talk radio host, and I do content that way. I have played football, basketball, baseball back in the day at high school and collegiate level, but I am not a lawyer by trade. A lot of people have been involved and watched my Deshaun Watson series. I've had 4 videos out there. They've all done tremendously well. This one is going to be a different take on the situation. As you know, I always tell people it's not about the emotions of the thing. It's about what the facts say on the ground. And my job is to break that down to the best of my ability and give you the real in it. And sometimes the real can go with the flow. Sometimes it can go against the grain. My objective is to talk about what I see, what I break down, and how this thing is moving. So the first thing that we got to discuss in this situation is, I got to keep it real. The NFL Players Association did themselves no justice. They didn't do themselves any favors by the collective bargaining agreement. The collective bargaining agreement says plainly that Roger Goodell has the ability to do what he's doing. Judge Sue Robinson, in all likelihood, was a pawn in the game. Let's be clear about that. She delivered a decision of 6 games. She goes through her conclusion and gives you all those conclusions to why. I'm not going to waste too much time on the conclusions. I did that in the video, and you can check that. It's linked in the description. But the NFL Players Association had an opportunity to veto that. They had an opportunity to say, no, we're not going to do that. But since they didn't, now Roger Goodell, the ball's back in his court. And when dealing with the NFL, you have to understand that they're going to play to win every single time. Billionaires don't get to be billionaires by letting collateral damage and loose ends, so to speak, lay around. They tuck that in and they do exactly what they need to do. They're calculated, they're cold, they're precise, and it's all business, no feeling. So when you're playing with the players union, there's no way you should let your leadership should let this small stuff happen, because you never think that this is going to be a case where, hey, who knows, this little clause right here doesn't mean anything. Who would know that Deshaun Watson was going to be in this position? Well, it looks like the NFL did. And the NFL does what it can to make the sentences in the collective bargaining agreement and in conduct policy, they make it towards the last bite at the apple always comes to them. So let me give you the facts on that. And why do you say that, G. Bush, and where did you get that from? Let's go ahead and immediately talk. This is from the collective bargaining agreement. It says, NFL Players Association announced Sunday that it would not appeal Robinson's decision. The union has 2 days to respond to the league's notice of appeal. Per the personal conduct policy, the appeal will be processed and on an expedited basis and will be based on a review of the existing record, meaning that no new evidence or testimony can be permitted. So now you can't even bring new testimony in. It's all heard. All they're essentially doing is bringing in another guy who's going to come in and talk about it. The commissioner or his designee, and the designee is going to be announced within, I guess, a couple hours, couple days, whatever the case may be. It is going to be of Roger Goodell's designee. It won't be Roger Goodell, but it might as well be him, because we all know what the verdict is, right? They wanted a year indefinite. They're going to probably get a year indefinite because that's his designee. And the designee will issue a written decision that will constitute full, final and complete disposition of the dispute and will be binding upon the players, clubs, and the parties to this agreement, the CBA states. Now, that's pretty ironclad. That's pretty ironclad, bro. Ain't nothing you could do about that. In looking at some of the legal doctrine and documentation, that's in the CBA. So that's one strike against the Players Association because that is clearly stated in the collective bargaining agreement which you signed. Nothing you could do about that. There's also a couple other things that work against the Players Association in this case. Traditionally, arbitration is very, very difficult to overturn. In fact, there are some statistics out there that say it's anywhere less than 20% of appeals that go to federal court have an opportunity to even overturn an arbitration award. Now, some might get confused because they said, well, Sue Robinson gave an opinion, and why isn't that standing? Well, I just read you the clause. Roger Goodell has the ability that anything over 0 games, he gets the final say. Whoever he puts in the points and they make a written decision, that is binding in the CBA. So that already looks kind of bad. I mean, now you're like, okay, well, what's the next options? Let's go to arbitration rule. This doesn't look too good for the Players Association either. So let's go ahead and add that to the screen and we'll talk about it. Now, this is the intro to it. So there is, and we'll talk about this coming up in a moment. There is some wiggle room for the NFL Players Association in terms of seeing that they can get this award or the arbitration ruling overturned. So there's a new option to appeal arbitration awards within the arbitration process. This is in 2013. So basically gives an overview. It says arbitration is a faster, less expensive way to resolve disputes. One significant drawback of arbitration, however, is there has been almost no way to overcome an aberrant decision by an arbiter. So, and there's a couple of ways you can get an arbitration ruling overturned. It has to be blatant corruption. It has to be blatant that the arbiter didn't understand the law or what his ruling is against the current law, and it has to be blatant, outright incompetence and corruption, which is very difficult to get because arbiters are usually federal judges or former federal judges or attorneys or law practitioners of law who they're not going to give anything egregious in their write-ups to give you any opportunity to say they're incompetent. But we'll go in and read the rest of this. One significant drawback of arbitration, however, is that there's been almost no way to overturn an aberrant decision by an arbiter. Even when the arbitrator applies the wrong law or plainly mistakes the facts, courts will rarely disturb the award. To address this concern, the American Arbitration Association has created a new option of optional appellate arbitration rules to provide an expedited and complete review of the arbitration decision. What you need to know for the most part of what I'm talking to this for the purposes of this is that that doesn't look good because it's still really hard to overturn arbitration. Let's go and continue to say, why is that very difficult? So we'll continue. Under the Federal Arbitration Act, a court may vacate an arbitrator's decision only in limited and unusual circumstances delineated by the act, such as an arbiter has misconduct, refusal to hear material evidence, or the arbitrator exceeds his or her powers. Courts will not entertain claims that an arbitrator has made factual or legal errors. Florida statutory and decisional law is similarly restrictive. So even if they interpret the law incorrectly, they still ain't going to overturn it. Some courts have interpreted that arbitration statuses include an additional narrow grounds for vacating an award, such as finding the award completely irrational or manifest disregard for the law. These are difficult standards that are rarely met. For example, the United States Courts of Appeals for the Second Circuit vacated awards because of manifest disregard of law in only 4 of 48 cases and considered in a 40-year period. Nevertheless, these exceptions allowed a narrow hope of court vacating the erroneous arbitration awards. And that, as you can see, they have they have all of the court precedents. They have all of the cases that the case law that they're going to point to those right here in 2008 Supreme Court in Hall Street Associates LLC versus Mattel Inc. They give you where they're getting that documentation from. So what I'm just doing is setting up the fact that guess what? It ain't looking good for the NFL. PA. It's not looking good for the NFLPA because one, we already see that in the policy, Roger Goodell, his final decision is binding. Two, we go to arbitration laws in the United States Court of Appeals. Guess what? They're traditionally very, very, very sticky to turn those over. You pretty much got to be a liar, a cheat, and do something absolutely fraudulent. Now I know what you're thinking. The NFL is fraudulent a lot, right? You're thinking the NFL be doing some wild stuff, but listen, in this case, the NFL also has another group of things that are in its back pocket. Let's go to this. The NFL has had people take them to court. Let's look at the Zeke Elliott case because I think it does a good job of telling you exactly precedent, how judges look at this stuff, and the likelihood of you getting an overturned arbitration award. So in employing legal arguments that echoed previously raised by Tom Brady and Adrian Peterson and their unsuccessful federal lawsuits over suspensions, Elliott contends that the NFL has unlawfully applied Article 46 of the collective bargaining agreement. In doing so, Elliott insists that the NFL failed to provide him the basic elements of fundamental fairness required by law. For Elliott to prevail in court, he must show that the process used by the NFL to judge him was badly flawed. So we've already seen, as if you look at previous case laws, I mean, it's pretty ironclad that these people not overturning nothing, even if you do have misinterpreted the law. It's just, that's crazy. I don't know what kind of bar you got to have. Oh, I got one. This is why you stick around for what my suggestion is to the NFL Players Association. It's not all done. There are a couple of ways that you can get around these laws, and I'll tell you about that coming up. I may put this in a two-part series because I think you guys have to understand how dire it is to get to this point. I always tell people, read your contracts. Tell people how many times have people been out here in the music industry signing their life away, football industry. And traditionally, the NFL Players Association is the weakest out of all of the major sports. Baseball and basketball are much stronger unions than the NFL Players Association. In fact, I can't even find cases where the NFL Players Association has won or really had the NFL owners over on the ropes. Just hasn't happened. And as you can tell, as we continue to look through this information, you'll start to see, wow, G. Bush, this stuff is really like, I just don't do this for you guys just to say that I'm trying to be cool. I do this because I believe in facts over fiction. And so sometimes I may not agree with the tactics of the NFL, but I'm just showing you what you up against here because I'm not a lawyer. But this stuff look real open and shut to me. But there is a way. We'll talk to you about that coming up, man. You want to keep it locked. Don't play with your boy. We got it all the bases. Hit that like button, hit that subscribe button. We working over here, man. I guarantee you there's not another guy doing this. There's not another guy on the radio, television. I'm not on full time. I don't got my own radio show 5 days a week. I don't do all my different stuff. I do this out of a passion project, man. But I really believe in investigative work. I really believe in thought-provoking work. So that's why if you guys like this content, takes a long time to do. I appreciate you. All I ask is hit that like button. Make sure you share this and continue to support local content. Support guys that ain't under the machine. You don't got to be, I don't validate somebody because they on ESPN or Fox. Validate the content. I'm a big fan of independent content on YouTube. I got YouTubers, I got bloggers on my show every single, I'll do a radio show called The Barbershop, and I bring people on YouTube that got thought-provoking content because I think that's the next wave of where our stars come from, the Paul Harveys, the Bob Costas, the historians of what we want to do. Vince Scully. These guys are pioneers of what we want to do, and this is important. So let's continue to go on. So this is why it's very difficult. For Elliott to prevail in court, he must show that the process used by the NFL judging him was badly flawed. But differently, whether Elliott is guilty or innocent of battering his girlfriend, Tiffany Thompson, is not the legal question. The legal question is whether the NFL adequately adhered to an agreed upon process for reviewing Elliott's behavior. So let's get this. It's not about whether or not he did it or not. I think people are missing that point with Sue Robinson. It doesn't matter if she believes he did it or not. The only issue is, and the only thing that you can wiggle and go to court on is saying it's the process. Was the process adequate? Was the process detailed? Did they follow the process that they said they were going to do? Keep that in mind. That's going to come back in. You say, G. Bush, how are they wiggling? This looks crazy for them. How are they wiggling out of it? Just wait. So Elliott's complaint follows the same construct Brady and Peterson cases, even though those cases dealt with different factual situations. Slightly underinflated footballs or corporal punishment of a child. They nonetheless center around the same legal question. Did the NFL follow the law in investigating a player, punishing that player, and through Article 46, reviewing the merits of the player's punishment? So as you can see, they don't got it. Listen, it don't have nothing to do with whether you're innocent or not. See, Deshaun Watson didn't go to jail. Deshaun Watson isn't, he's not, that's not part of the process. This is civil. We talking about the NFL's processes, right? And this is perfect right here. Let's continue on with the Zeke Elliott case and figure out why this is so crazy, right? So one of the things that we talk about that you're going to hear coming up is a temporary restraining order. And that is when you go to an appeals court and you're trying to get a stay so that the NFL can't immediately suspend Deshaun Watson just like that and just say this thing is over. So the NFL Players Association, I believe within 2 days here, has to, don't quote me on the time frame, but relatively quickly, they have to file a lawsuit stating that they don't agree with the arbitration. Put it to you like that. And so one of the things that people throw out is a TRO, which is a temporary restraining order. And people think that this is very easy to get. No, it's not. As you can see, this is how law works, right? In the United States, man, it's you got to know your rights. You got to know how difficult this stuff is to get, and you have to also know exactly what hurdles and hoops you have to do to prove your case to even be eligible for this stuff. So just to give you a hint, if there was a temporary restraining order for Deshaun Watson, what would happen is a court would say the NFL is not allowed to suspend him indefinitely or whatever the ruling was with the award or arbitration. Then Deshaun Watson theoretically would be cleared to play until this issue was settled in court. That could take up to a year, depending on how much they got it on the docket, right? That's why you do arbitration, right? You do arbitration because it's less lengthy than going to court and having to sit and wait, and it's very expensive. However, the NFL has unlimited money. However, the NFL Players Association has unlimited money. That's thrown out. Secondly, but the time is a thing. Who knows when they might get to it, which can end up seeing, like in the Tom Brady case, you could play football until you have to go and they get to court. But it's difficult to do this. So let's see what happened to Zeke Elliott. He wanted one of these. As mentioned, Elliott also filed a petition for temporary restraining order, TRO. The purpose of the TRO would be to ensure that Elliott remain eligible to play games for the Cowboys until court resolves the question on whether it should vacate Henderson's pending arbitration award. The court's review of the arbitration award could take several weeks, possibly months, meaning a temporary restraining order could ensure that Elliott is available to start the 2017 regular season and perhaps well into the season. In the case of Deshaun Watson, that's their process, and that's their thought process and rationale as to why they want one. Unfortunately, for Elliott, usually courts usually reject temporary restraining order petitions. Now, this is what you have to clear. This is your burden. In law, temporary restraining orders are regarded as extraordinary forms of relief. A petitioner for TRO, here Ezekiel Elliott, must demonstrate 4 prerequisites: a substantial likelihood of success on the merits. So most likely they're going to win if this thing plays out. A substantial threat of immediate and irreparable harm for which has no adequate remedy at law. That's kind of hard to prove. Let's give you an example. Immediate and irreparable harm. So say they want to suspend Deshaun Watson for a year. Well, the Cleveland Browns have already said they push his contract back. So in court, if you're trying to say this is immediate and irreparable harm, that means he's going to lose 1 year of his contract. He's going to lose a whole year of his contract. He's never going to be able to make that money back. And since they're not able to find him, they're not finding him, Your Honor, we've already lost we're going to lose a year worth of salary. Well, there's 2 things wrong with that rationale and thought process. Since the Cleveland Browns have already one time taken his salary and vacated it and moved it around to a place where he would not lose that substantial amount of money due to finagling with his contract, the judge will simply say, well, it seems that you've moved this contract before where he wouldn't lose that much funds, and I'm sure you could do that again, couldn't you not? That kind of sucks, don't it, right? You thought you was doing it for good and just reasons, and it made sense at the time, but now they can use that against you. They would also say, too, in the likelihood of that, if the NFL, say, for instance, fined him $10 million or whatever they want in this next arbitration ruling, which will be binding. If the league simply says we fined him $10 million, the league can give him $10 million back. These guys are exorbitantly rich, so it's not like they're doing anything. You could possibly argue that a player playing a violent, savage game like football, missing a year is immediate and is kind of harmful because you only have a certain amount of time to be able to play that sport given the violence. But I think that the other two or three points that the NFL would bring up are more substantial than that. So it's very difficult. Let's go to 3. The greater injury will result from denying the temporary restraining order than it's being granted. Now, if you go back and look at what Sue Robinson put in the case, she says that he has been guilty. Now, mind you, this is not on a criminal level. This is underneath the collective bargaining agreement conduct policy. She says it's the most egregious. She also said he could be potentially a threat to other people. So those things, right, kind of weigh heavily. It kind of weighs heavily. Like, that reads crazy. Like, so the greater injury will be denying the temporary restraining order. All they're going to say is what's the greater injury to Deshaun Watson? He can't play. He didn't play all last year. He said all last year because why? I mean, he just didn't want to play for the team. Why can't he sit now if he's going to be a threat to people around him? And he can't go to massage anybody outside of the organization? Now, you see, people, this is how I'm just going to be honest with you. I keep it a buck. I keep it 100. See, my job ain't to sway you one way or the other. My job is to hold up the mirror and say, this is what the facts bear out. Even when I don't necessarily agree with the actions of the NFL. I got to give it to you the only way I could give it to you. And that's real, that's raw, and that's authentic. You can't say bars without putting that R's in it. See, I'm sorry. Shout out to Arsenal. I'm going to show you in part 1 how difficult the case is. As you can see, it looked like you climbing up an uphill up Mount Everest backwards with no bungee cord. This thing is looking devastatingly hard, and that's by default. These people got smart people. Billionaires don't get rich by being suckers. Billionaires don't get rich by being soft, and billionaires don't get rich by not covering their butts, by not covering their bases, and by not being ruthless when it comes to things of bread and money. It is what it is. So let's continue to tell you why this case is tough. Each of the elements that we just discussed before, those 4 parameters, is difficult to show. As explained more fully below, the law likely favors the NFL on whether this judge who was, presiding over the Elliott case in 2017 should vacate Henderson's award. If Judge Mazin reaches that conclusion, then Elliott's petition for TRO must fail, since he wouldn't have shown a substantial likelihood of success on those merits. When you present your case as to why Roger Goodell in the Deshaun Watson case, why his award should not be binding and final, you got to have some extraordinary stuff behind you. You got to have some extraordinary stuff. And as I said before, I don't know if the NFL Players Association is willing to go to the lengths that it is going to need to work with this case. Because I'm going to tell you what, they have to go to a place that no one has ever gone before. But they got a case. It's narrow. It's going to take a very skilled lawyer to do it. But from my research, I would be interested if any lawyers are out there. If you watching this, I'm not a lawyer. Give me some feedback on it. Maybe am I wrong? Tell me I'm wrong. Hey, listen, this is, for me, as a project. This is something that I'm just doing for some thought-provoking conversation and content. But let me know if I'm wrong, if I'm in left field, I'm completely out of the place, or if the framework is consistent and solid, if you can get a skilled guy to argue this argument. But that's coming up in part 2. Part 1 is just showing you what the uphill battle look like and what's facing the NFL Players Association. So when we talk about is here, and they say Roger Goodell's power to discipline stronger than ever after the win versus Adrian Peterson. So Roger Goodell is 3-0. People, he got Tom Brady up out of here. He got Adrian Peterson up out of here. And on top of that, he has gotten Ezekiel Elliott up out of there. So it goes on to say, even if Judge Mazin believes that Elliott has a substantial likelihood of success on the merits, the judge may nonetheless refuse to grant a temporary restraining order on the grounds that Elliott's injuries would not be irreparable. So even if he thinks that's profound, that goes to show you how tight and how people interpret the law. That's why it's very important. It depends on where you go. It depends on what state that this is going to be in, because some judges are going to be conservative judges or liberal judges or certain judges that, and these circuit judges, look, by the way, these guys rule, they do what they want to. I mean, these guys are, that's why elections have consequences, people. These judges ain't nobody coming in and sanctioning no judge. These people are there until they want to be there, not be there. So it's all dependent on what circuit you go to, what judge you're going to get, and how they're going to interpret the law. But right now, according to arbitration laws, this is looking crazy. The NFL will contend, watch this, and we talked about this a little bit earlier, wouldn't be irreparable. And it's hard to have irreparable when you got people that got more money than God knows what. Usually, judges find that a particular harm isn't irreparable if monetary damages can later cure it. Whoa. I could just pay him back, right? The NFL would contend that it would reimburse Elliott for any lost wages if Judge Mazin later vacates Henderson's arbitration award. Elliott will have to convince the judge that monetary damages for missed games wouldn't cure other manifestations of harm from the suspension, such as interference with the development as an NFL player, his accumulation of career statistics, and the reputational stigma that accompany damages due to endorsement opportunities, and attach a player suspected of domestic violence. So, I mean, I don't think I could say it any better. The NFL would contend that it would reimburse Elliott for any lost damages if they later vacate Henderson's or arbitration award. And in the case of Deshaun Watson, they can even say, well, the Cleveland Browns, they're really good at making sure that he won't have any financial losses. Look at the way they structure his contract. Whew. I'm just here to give it to you. The NFL Players Association is up against such a huge uphill fight. In what way is it possible for them to seemingly overturn the NFL's ability to seemingly just have ironclad writing? It's intentional like that. Well, there's a couple things that you can do, and I think it all starts by going back to the regular policy. If I have to believe that Roger Goodell has the final say, and it is ironclad that final say of his arbitration is binding. It says it in the CBA. He has the right to appeal a decision, anything over 0 games, which he's going to do. He has the ability to go find a independent arbiter that he wants and then make the decision that he wants, and then it's final. That's the right. It goes back to contracts, and the Players Association signed it. But that's water under the bridge. What do we do about it now? Well, the Players Association has an opportunity to sue. Now, what grounds are you going to sue on? If you've already seen that courts and appellate courts don't really overturn arbitration rulings, what are you going to do? Well, let's go back to the ways that the NFL has won, which is the way they structured their policies. Well, let's go back to see if we have anything in the policy that we can use against them. So, it goes by here saying it's a privilege to be a part of the National Football League. By the way, this is part of the collective bargaining agreement on player conduct and conduct policy. It's a privilege to be a part of the National Football League. Everyone who is a part of the league, now they signed everyone and underscored everyone. I think everyone, there's no other thing other than everyone, right? So the league did something that was wrong here. They said everyone who is a part of this league must refrain from conduct detrimental to integrity and public confidence. 2 things: integrity, public confidence in the NFL. And the first thing they do in the chronological order amongst power is issue the names. This includes owners, coaches, players. Owners is first because they are at the top. It is their organization. When Enron got in trouble, the CEO can't say, well, I didn't know what's happening. Doesn't really work. When there's insider trading, when there's financial misdeeds, CEOs, CFOs, COOs are responsible for what goes on in their organization. And it's no bigger than NFL owners. Then it goes coaches, players, other team employees, game officials, employees of the league office, the NFL Films, NFL Network, or any other NFL business. If you got the name NFL, you all fall under the conduct policy. Conduct by anyone in the league that is illegal, that's it, violent, dangerous, or irresponsible puts innocent victims at risk, damages the reputation of others in the game, and undercuts the public respect and support for the NFL. We will endeavor at all times to be higher character. We must show respect for others inside and outside of the workplace, and we must strive to conduct ourselves in ways favorable that reflect on ourselves, our teams, communities we represent in the NFL. At the end of the day, we'll stop with the recitation of this, because obviously the NFL doesn't believe in that. Because in the midst of this, it says clearly, everyone, owners. Let's continue on. We know that was not the case. We understand that that was not the case. We got that from A, the fact that we've seen Robert Kraft receive nothing. B, we've seen the Houston Texans give over 30 settlements named in the same lawsuit as Deshaun Watson, and they have gone about training camp as if nothing happened. Now, a lot of people consider that just to be hypocritical. A lot of people consider that, oh, it's just the way it is. Things will never be the same. No, that's a little, it's a little different. You don't do that because you're being nice to me. You do that because you're legally obligated to do that. You say, what? Let's continue to build the case. Remember what I just said. As we go through here, we go back to Judge Sue Robinson, who's been superseded. But there's one thing that you can use in here. You see, this is open to interpretation. We've used Sue Robinson saying that Deshaun Watson was a threat to others, that she believes he did something, that she believes that he could never go to another masseuse outside. Everyone's been drilling down on that, but wait. It goes two ways. See, the NFL has made some missteps here as well. She says why she gave Deshaun Watson 6 games. Here, the NFL is attempting to impose a more dramatic shift in its culture without the benefit of fair notice, and consistency of consequence. Hold on. Very understated. Fair notice to, and this is the key, and consistency of consequence for those in the NFL subject to the policy. It's very clear. It's very clear. We'll go back and tell you who's subject to the policy. Everyone. Who's subject to the policy altogether? Everyone. So when you have a judge already saying, well, you didn't really give anything to these people, you really didn't investigate that. Now you've opened yourself up to what we call breach of contract. You have breached your contract in terms of the collective bargaining agreement. You have chose selective enforcement of your rules, and you've chose to let owners who are part of the collective bargaining agreement walk free by yourself because you can. Now, I told you before that an arbitration is very difficult to overturn, except in these certain cases. So when you are in arbitration and you have a collective bargaining agreement, a collectively bargained agreement is a contract. If you do not hold people to the same standards, you are in breach of contract. Let's take a look at this. See what this says. When can failure to follow a policy lead to a legal claim? As with most rules, there are exceptions to laws governing employment at will. In some situations, an employer is required to follow their own policies and apply them consistently. See, I'm just saying, you notice the word consistently. They apply their policy when it comes to players, but when it comes to ownership, it's not consistently. And may be subject to legal liability. For example, the failure to follow established policies is illegal. It is illegal when they are part of an employment contract or collective bargaining agreement. It is illegal. It is not just a faux pas. It's not just hypocrisy. It's not just, the NFL is kind of shady. It's not just, the NFL, well, then maybe, it's discretion. No, it is illegal if they are part of an employee contract or collective bargaining agreement and they choose not to enforce policies and apply them consistently. Failure to uphold policies as evidence of discrimination. I argue with 70% of its players being African American. I argue with 100%, 99.9% of ownership being all white, the majority of coaches being all white, the majority of decision makers being all white. I believe that the NFL may have an issue if across the board they're not being fair, equitable, not only in policies and conduct, hiring practices, employment practices, discipline, and resources and benefits paid out. So those are the 5 tools in which we start to see areas that not only it could be illegal, but it could be discriminatory. If it can be shown that an employer's decision to disregard its own policies was motivated by discriminatory animus, there may be a viable claim for employment discrimination. For example, consider an employee who was terminated based on attendance issues, but according to the company's written attendance policies, had not yet violated a policy. The failure to apply a written policy as it was written, that's the point. That's the point. The failure to apply a written policy as it was written to a particular employee can be evidence of discrimination. It's narrow, but I tell you what, got a ring. I'll go back to who's part. All together, boys and girls, who's part of the collective bargaining agreement? Everyone, including owners, coaches, players, and other team employees. Let's continue to go. You said, well, that's a reach, G. Bush. That's a reach. You can't just say because, you know, that they happen to, the guys that are getting in trouble happen to be African American. That just seems off base. Do you have legal? Well, let's talk about this. What are the protected groups in this country? There's protected groups, entities that you cannot discriminate based on. Let's see. Applicants or employees and former employees are protected from employment discrimination based on race, color, religion, sex, including pregnancy, sexual orientation, gender identity, national origin, and age, disability, and genetic information. They are also protected from retaliation, from filing a charge or a complaint of discrimination, participating in discriminatory investigations of lawsuits, or opposing discrimination, for example, threatening to file a charge and complaint against of discrimination. Well, see, let me just get this correct now, because I do remember Daniel Snyder filing a reverse investigation of Miss Wilkerson, to which Roger Goodell had to come back out and say, oh no, there was no shadow op program. I'd argue that not only is there a class action lawsuit available for race, but sex and gender as well. Over 50 credible or sexual harassment allegations against the Washington football team, Commanders, whatever you want to call them. You see how this thing moves? Let me ask you a question. Did Dan Snyder lose? What came of that? What came of that? I don't remember much. I remember him leaving a boat, running away from a subpoena. You see where we're going right now? See where we're cooking, right? We talked about in what ways an arbiter can be disqualified, can be overturned, the ruling, the award overturned. Well, let's go to this. This is one of the ways you can do it. If Roger Goodell is the end-all be-all, evident partiality, corruption, or prejudicial misconduct by an arbitrator. The next ground concerns wrongdoing by an arbitrator. There does not appear to be any definitive test for evaluating whether an arbitrator was evidently partial. with one court commenting that evident partiality, like obscenity, is an elusive concept. One knows it when he sees it, right? But it is awfully difficult to define the exact terms, right? Generally, however, this ground reflects that an arbitrator has an affirmative duty to disclose any dealings that might create an impression of possible bias, and that the failure to do so undermines the appearance of the propriety and the confidence and fairness of the proceedings. So I state this. If Roger Goodell is the ultimate arbiter in this decision, and his word and last word is binding, how can that be a binding contract if he is already biased and not partial? It undermines the appearance of the propriety, of confidence, and the fairness of the proceedings. So if you have a process in which you say, I'm going to have an arbiter, Sue Robinson, who is impartial, she's going to look at all the information, she gives 6 games. Because because of an arbitrary rule of, if she gives 0, I won't say anything, but anything other than that, I got the process to just overturn it, appoint my own guy and put him in there. This is law. It undermines the appearance of propriety and confidence and fairness of the proceeding. By default, you're corrupt. By default, you're biased. By default, you can't be the prosecutor as well as the arbiter. You can't be the arbiter as well as the appealer. You can't be the appealer and the final decision maker. By default, on face value, I know you say you can't put exact terms on it. Generally speaking, you know it when you see it, according to these quotes. So I think we'll stop right there. What we've come to the conclusion with in this section of it is we've shown the uphill battle the NFL Players Association is dealing with. We've shown you just how difficult this fight is going to be. We've shown you, based on case law and precedent, how difficult it's going to be for Deshaun Watson to get a restraining order to play this season. We've also seen how difficult it is for Roger Goodell to be overturned by an appellate court. We've also seen that there are provisions in there, even if they believe they are going to be successful, the NFL Players Association, Deshaun Watson still may not play because he has to prove in a court of law that it's irreparable damage done to him sitting out while this whole thing is continuing to move forward in a court of law. However, there is a small, narrow avenue, and we've also proved that ownership was not held to the same standards. We've also shown you that that is just not hypocrisy. That is illegal. That's breach of contract. They must do that in a collective bargain agreement. And we've also shown you there are already seeds of discrimination that you can push, point, prod to, that really might open this case up for a class action lawsuit that could get wild and crazy, kids. Coming up in the next episode, part 2, you don't want to miss it. I go through the 5 tools that are evident and available to the NFL Players Association that will blow the lid off this case. I'm telling you, it is complete, it is systematic, and this is going to be something you don't want to miss. As always, if you like this content, hit that subscribe button, hit that like button, continue to support independent thinkers, continue to support people that use this and have this, but use this as well. It's always fact over feelings, and you know how we give it up on the barbershop. We'll see you next time. You don't want to miss this.